Ladies and gents, welcome back. The 1930 Natural Resource Transfer Agreement, it's a mouthful. I had to read it off the screen because I didn't want to get the words wrong, is on the table now as if it's something everybody knows about. And well, here's the thing. I did a story yesterday talking about this. And well, I wasn't that informed on what this act was and what the relevance and the significance of it was. But so for that reason, I brought in someone I knew would be knowledgeable on the subject. And so welcome Keith Wilson to the talk here, because I want to really get to the bottom of this. And thanks for joining me today.
You're welcome. Good to be here.
So when I was doing my research and looking into what this was and finding out as much as I could to make a video on the subject, because it's newsworthy and this is something that's being talked about right now, your name kept coming up. There was many times over the years on Twitter that you had spoken about this act specifically in whatever it was, the line of work that you were doing at the time or discussions that were happening in the public arena. So why is this on the table? Why is it that the federal government feels that they have the negotiation tool? Well, first off, tell me, what is this act?
Okay. So what happened is Canada formed, Alberta and Saskatchewan, they've always been treated a little differently in the early days of our Dominion. The federal government was focused on settling the lands through the homesteading policies, developing the railway, McDonald's vision, and so on. And so Alberta and Saskatchewan and Manitoba, to some extent as well, developed legally very differently than the rest of the country, different than British Columbia and Saskatchewan, and Ontario and Quebec and so on. One of the things that happened differently was, unlike other provinces, the mines and minerals, the oil and gas, the coal, the hard metals, iron ores, all that stuff that we mine, copper, gold, whatever, was all owned by the federal government, as was water. So the water that comes out of your well, the water in front of your property on the lake, this is inland waters, rivers, beds and shores of those were, the title was vested in the federal crown, and also forestry. So it was a grievance point leading up to the creation of the provinces. And once the provinces were created in 1905 for Alberta, it's like, hey, we don't control any of our resources. And Saskatchewan doesn't either, but BC does, and Ontario does, and Quebec does. This isn't right. And it created all these problems. It really perpetuated this whole idea that Albertans and Saskatchewan were the hewers of wood, and we would, we just supply the resources to central Canada for them to manufacture. So through a series of negotiations, Premier Brownlee in 1928 negotiated the Natural Resources Transfer Agreement with Ottawa that would have Alberta take over ownership of the mines and minerals, the water, the forestry, and so on. That was codified through an amendment to our Constitution in 1930 that included the other two provinces, to put the three provinces of Alberta, Saskatchewan, and Manitoba on an equal footing with the rest of the country, so that the provinces and its citizens would own and take the benefit from their natural resources. And it is part of the Constitution. So when you hear a federal minister, the Attorney General for Canada, Mr. Lamente, talk about rescinding that, wow.
Yeah, it's big news. It's big news. And I was going to get into that, the idea that the federal government would even have we're talking about a constitutional amendment here, and the federal government feels like they have that as a negotiation tool, as if they could just rescind that at will, as if it wouldn't need some sort of constitutional that's a crisis in its own right. But we had a joint statement from the premiers of the three provinces got together and put out this statement saying Prime Minister Justin Trudeau needs to tell Canadians today that the federal justice minister David Lametti was not speaking on behalf of the federal government when he said he would look at rescinding the 1930 Natural Resources Transfer Agreement with the Prairie Provinces and strip away their constitutional authority and control over natural resources. I mean, the federal government, we know since 2015, has been habitually line stepping and overreaching when it comes to the provinces, but also individual citizens in Canada. But is this a line that they're able to cross?
Well, when this blew up yesterday, I thought, first of all, what's going on here? And we know that through Bill C-69, it's not Bill C-69, but others have called it the No More Pipelines legislation. And that's the one where the federal government a number of years ago amended the Review Acts, environmental assessment reviews and so on, to make them so onerous and so nebulous. Like you have to examine the impact of a proposed pipeline on the intersection of sex, gender, and other identity issues. Like, what does it even mean, let alone how do you carry that out? And that's actually in the act.
Yeah, it's
by
nonsense.
the way. That's
it's absolute
wording.
nonsense.
It's patent nuts. So we know that there's been this push on from Ottawa to control and prevent Alberta and to a lesser extent Saskatchewan from developing, and northeastern BC, fossil fuels. Well, I thought, if you can't, and that case is interestingly enough currently before the Supreme Court of Canada. It was heard was a week and a half ago, as to whether or not that legislation is an intrusion into provincial jurisdiction in ultra vires. But I thought, well, geez, I guess another way to take control of the minerals development is to say, guess what? Just kidding. In 1930, we're rescinding. You don't own it anymore. And then I thought, this is preposterous. So I actually got out the crumpled up version that I have here, in the old font. And I read it. I was like, is there a rescission or a unilateral amendment clause? And there isn't. And I thought, okay, that would have been bad. So you're right. The only way they can actually do this in a lawful manner would be to amend the Constitution and use the amending formula, which I just don't see how they could do that. But, the difficulty I have, Clyde, and this, so many other lawyers have, is since COVID, governments have consistently done things that are glaringly offside the Charter, glaringly offside their own home statutes, and there's been no repercussion for it. To a large extent, our courts have become parrots of the bureaucracy. The blindfold on Lady Justice is pulled right down and looks to see, oh, whose team are you on? Oh, government team, better rule in your favor. So who knows what could happen with this? The premiers are taking it seriously, and I think they should.
Well, it seems like if this were to go through, it would legitimately, under legal definition, create second-class provinces in the country, where certain provinces have particular rights and other provinces don't have those rights. It really seems
Absolutely.
that would be the case. We're not in homesteading Canada anymore. We're a developed nation, and we're a first world country. If you
go back
anyway.
and if you look at the writings, the academic writings, some of the leading piece by Justice Laforêt and others on natural resource development and their history in the Constitution, and they will talk at length about how in the 1920s, the driver for this agreement was to correct the fact that a second-class citizen type province had been created. That was recognized and agreed to by all parties, that we'd created two classes of provinces, and it needed to stop. We needed to be treated equally, and that was the purpose of this agreement. So to have the minister musing about rescinding it is incredibly irresponsible, and could create a constitutional crisis or worse.
So he brought this up, and he brought this up with native bands. He was having talks with First Nations leaders at the time. What prompted this? What was the thought process behind this? Not that you're going to get in Lametti's head, but what is the What was going on that led to the moment where Lametti would say something like this?
Well, it's probably to fully explore this is going to need another interview, but I can highlight this. It was in the context of UNDRIP, which is the United Nations Declaration on the Rights of Indigenous People, and the Canada legislation, I believe it was C-15 at the time, to implement the adoption of it. And I think some had suggested that maybe we need to go all the way back. The chiefs, some of them, were suggesting they need to go all the way back to revisiting the Natural Resources Transfer Agreement. In other words, undo the transfer to align with UNDRIP. So I think that was the context in which, well, I know it was because I searched out every quote tape that I could find of Lametti today and found the longest ones just to make sure I was seeing it in context. And that was the context in which it was discussed, was having UNDRIP and its principles even override the Natural Resources Transfer Agreement.
Well, that's unbelievable. Now, that, like you said, I'm gonna have to have you back to talk about UNDRIP now. So, well, I guess we'll just leave it at that for now, and we'll see where this goes with the premiers putting pressure on the federal government to get Lametti to take his words back, at least disarming his dangerous rhetoric in this case. Keith Wilson, thank you so much.
Thanks for having me on.